Well, welcome officially, everyone, to what we're going to do. And of course, as this starts, the sun gets it right in that place that it's going right down the middle of my face. So apologies for that. But welcome, everyone. We have an exciting panel. We're going to be talking about trial preparation and how that exists in this virtual world. A couple just sort of logistics comments. Number one, which is super important, thank you for including us on what I understand you guys do as a celebration or a monthly happy hour version. So I hope that is true because we have all come prepared. So we have our cocktails. I hope you all do too. Cheers. We're going to do this conversation style. Cheers. Second, we just need to talk about the fact that we're doing this all virtually, which is apropos of our presentation. And so while we hope we don't have any glitches, we could. And if that happens, just bear with us and we'll get back up and running. I don't know if any of you saw this, it came on this morning, I guess it happened yesterday, the Supreme Court arguments. For whatever reason, we've decided it was one of the justices. I don't know if that's fair, but someone flushed the toilet in the middle of the arguments and it was all heard across the world. And so hopefully that doesn't happen today. You might want to put your phones on mute. As I was saying, though, we have an exciting group of panelists. I was rereading, even though I know who these folks are, their bios about an hour ago before we started this, and I'm even more impressed. So I'm going to brag on them for a minute. Let me see if I know how to advance this. And Ashley, I'm going to have to ask, do I already have rights to do that? Here we go.
You got it?
So here we go. Can y'all see that? So perfect. These are our panelists who you may also see across the top of your screen. And I'll start kind of in order. So Melissa Zukowski is in-house counsel at Flex. She serves as the Vice President of Litigation and Disputes. She joined in 2014, and prior to that, she worked as outside defense counsel as a partner in a law firm in Ohio. I'll get to that in a minute, but what she does at Flex as the Vice President of Litigation and Disputes is she leads and manages commercial litigation, and that includes hiring and oversight of outside counsel, provides strategic and legal advice, direction to the business partners related to litigation and to commercial disputes. And she develops training and communications for management on new legal trends and litigation avoidance. She also provides support for the FAS 5 and audit reporting processes. So a lot of her experience is going to be very relevant from an in-house counsel's perspective on our discussion today. And she also brings to the plate her experience as outside counsel, where she spent 10 years at Ulmer and Byrne, and most recently as a partner there. And she was defense counsel, including for consumer claims, where she handled streamlining and navigating of e-discovery, coordinating third-party vendors, fact gathering, responses to discovery, also coordinating contract or staff attorneys, and generally figuring out cost-saving measures, both as in-house counsel and as outside counsel, while she also oversaw or worked on litigation. Flex, for those of you who may not know, is in your neck of the woods out in the Silicon Valley, but it is a sketch-to-scale solutions provider that designs and builds intelligent products for the connected world. Approximately 200,000 professionals across 30 countries. Flex provides innovative design, engineering, manufacturing, real-time supply chain insight, and logistics services to companies of all sizes and at various industries and end markets. Melissa, thank you for joining us.
Thank you for having me.
Judge John Wynn, who at my screen at least is up on the right, is now retired, but served on the bench as a trial judge in the Orange County Superior Court starting in July of 2000, and I believe retired in 2013. Is that right, Judge?
Yes.
Okay. Obviously, as a trial judge, Judge Nguyen has a tremendous amount of experience handling both criminal and civil matters. From the criminal calendar perspective, he presided over thousands of criminal trials and cases, including misdemeanors, serious felonies, and 3 strikes cases. He also, when he started in his civil assignment, Judge Nguyen issued approximately 500 written rulings, and he instituted the first time tentative rulings on law and motion matters on the internet and by posting them on the front door. So an innovator as well. In addition to Judge Nguyen's time on the bench, he is also a teacher. He's taught at Chapman University School of Law, Whittier College of Law, Western State University, on other things, but including trial practice, mediation, and arbitration. He's also a frequent speaker at bar functions, including on ethics and trial techniques. With regard to APAVA, or related, Judge Nguyen in 2002 was elected by his peers to serve as the president of the California Asian American Judges Association. In 2005, he was elected as secretary of the National Asian American Judges Association, and Western State inducted him into its Hall of Fame and set up a scholarship bearing his name for needy Asian American law students. So, Judge Nguyen, it is an honor. Thank you for joining us.
Thank you. It's my pleasure and honor.
And an entirely different perspective, we have Dr. David Cannon, who is a jury consultant. Dr. Cannon is the co-founder of Trial Innovations, and he's based in Los Angeles. He's a leading trial consultant and has been in cases around the country from 3 different types, ranging from insurance defense and corporate litigation to capital cases and white-collar crime. So what he does, principally, for those of you who've not had the pleasure of using a jury consultant, he's involved in witness workshops and witness preparation, focus groups and mock trials, online juror surveys, continuing legal education presentations, voir dire and jury selection, and post-trial jury interviews. Dr. Cannon earned his master's and doctorate degree at the University of Alabama, and it's one of the few institutions in the country. I found this interesting because I wondered how you become a jury consultant. That institution is one of the few that offers a concentration in both psychology and law. So he gets the rare blend of expertise in psychology, communication, research methods, and the law. And he uses both that clinical and communication expertise for things like witness preparation, psychological snapshots of prospective jurors and jury selection, how to conduct voir dire and voir dire training. He also specializes in the effects of diversity in the courtroom and the effects of lawyer characteristics on juror decision-making. His research and statistical expertise helps with his online jury research, developing juror questionnaires, and conducting mock trials and focus groups. Dr. Cannon has authored several articles on voir dire and jury selection in bar journals across the country, and he has conducted research on attorney voir dire styles and its effect on jury verdicts. I didn't know that, David. We'll have to talk offline about that more. David and I, thank you for joining us. I appreciate it.
Thank you very much.
I am Kristen Walker-Protz. I'm a partner at Womble Bond Dickinson in California. I'm actually in our Southern California office, but I run our business litigation in California. And for the last 15 years, I've been a defense in business litigation and financial institutions. But before that, I was a DA in both Los Angeles and Riverside counties. And so between civil and criminal, I have about 100 jury trials. Actually, it's a little bit more under my belt, which helped me do all the trial work from a civil perspective. And then I also teach trial advocacy at Loyola Law School in Los Angeles. So you're getting a number of different perspectives. I'm really glad and excited that we have our panel, and so let's get to it. I should mention that we are entertaining questions as you go. The idea here is that although we want to be informal and informational, we're speaking to the audience, and so we want to tailor this to what you want to hear about. So please feel free to chat questions. I will cop to the fact that it is not my expertise necessarily to follow that. So Maggie Watkins, who I forgot to introduce, Maggie, I apologize, is also here. She is our client services representative, and she is going to be fielding your questions. So thank you, Maggie, for joining us. All right. And so the way we've kind of broken this down is a little different than some presentations maybe on trial. What we've done is we've looked at it from case development, sort of the earlier stages of trial. And then secondarily, we're going to talk about COVID-19 and the impacts on case development, discovery, and maybe even crystal balling it into the impacts on trial itself. And then if we get time, we'll touch on a few in-trial stories and issues, but really the focus is going to be on how do we get ready for trial and how could we do that different? So starting with Inception, I'll just share a few of my thoughts and then I'll turn it to the panelists. So I was very surprised when I joined the civil world from the criminal world, and I know we've got some DAs that have signed up in the audience. It was handled very different, and in part, I think there's some cost concerns. But instead of being on the offense and looking at the case and developing storylines and themes and labels and all the things I teach about that I think make the story come alive and be interesting to jurors, there just was very little time spent on that. So I think it's important to remember that you're shaping the case all through and especially at the beginning, and know your end game. Know your strengths and your weaknesses at some point and figure out how to maneuver around the weaknesses. If you have some unknowns, make a list of things you got to find out and develop your case strategy and risk exposure. Those are some thoughts that I have jotted down regarding what I noticed that's not happening. But Melissa, I'm curious from an in-house perspective, what suggestions do you have that attorneys, I guess it could be civil or criminal, but really it's civil, I think, that needs help here. What could be done differently on the case inception?
Yeah, Kristen, so you and I have discussed this a few times, and I think one of the things to back up that is important to emphasize is critical from an in-house perspective. And this is something that's been a trend for a while, but is particularly emphasized in this environment, is cost savings and making sure that we are able to justify a clear return on investment for everything we do. And so I think one of the flaws that I see in outside lawyer approaches a lot of times is they build the case from the ground up instead of backwards down. And so you'll see a lot of focus on due diligence in the form of document review, witness interview, discovery, even before there's formal requests. And that's ultimately important. But if you had to rank the criticality of various things, that sort of level of I-dotting, T-crossing detail, I think is less important than knowing where you're going. And in fact, starting out with those types of reviews without having a clear idea of the roadmap for where your case is going, I think is a lot of times a waste. So I've been really surprised at how much people don't just start with the jury instructions for the claims that are at issue and then sort of work backwards from there. As a case goes on through, most cases settle, as we all know. And as they go on through their different iterative stages, you can fill in as needed rather than needing to know everything about the case from the beginning. And I think you develop a better story if you think of it that way. And you also know what you want to go figure out. I'd also say, this is somewhat related to that point, but I've been thinking a lot about how we're going to mitigate, what we can do right now to mitigate risk in the inevitable wave of litigation we get post the COVID-19 situation. And it's a fluid situation. It's a dynamic situation. I'd say unprecedented in a lot of ways. And so we don't really know what's going to apply, what's going to be the standard. And so as we think about what we should be doing today, I think we should be skipping several steps ahead and planning that strategy and thinking, what's an average individual juror going to think about this conduct or this approach when, maybe the legal standard is what did a reasonable corporate citizen do? And that's what we're focused on. But I think there are genuine distinctions between the way an average individual citizen in a reasonable corporate citizen would view something. And so that's the document trail. That's the narrative we need to already be focused on, I think, today. And again, that applies to other situations just generally, but it's even more critical in this environment. So those are some of the things I think about, and I think I'd like to see. I'm most impressed by lawyers that come at things with that approach.
Good points, Melissa. Judge, I'm curious from your perspective, and maybe you can do a comparison since you've observed both, of criminal lawyers and how they're doing it versus what you've observed with the civil lawyers once they go to trial.
Are you asking me?
Yeah.
Okay. I think it seems to me that the focus of this workshop is about preparing a case for jury trial. Is that correct?
That's right.
Okay. As a judge, I have seen quite a few cases from run-of-the-mill cases to the very, very high-value cases where the attorneys did an excellent job in preparing the case of jury trial, and there are cases where attorneys fail to do exactly that. And there are many surprises in trial that result in the verdict that is so significant. I think mostly because of the counsel failed to prepare the case for trial. And so I think preparing the case, discovery, and gathering all the evidence and understand your case from the beginning to the end of the case. What is the theme of your case? What is the alternative theme of your case? What are the evidence that you have to be presented? What do you expect opposing counsel to present in their evidence and the authorities that they will be present? The question, are you ready to counter all those evidence presented by the opposing counsel or the authorities cited by opposing counsel? Many times I had counsel fail to recognize that, so they were caught by surprise quite a few times. So basically, those are general observations that I have.
Those are helpful. Thank you. You've certainly seen your share.
By the way, to be complete, I retired in 2013, but I continue to serve as a judge on assignment in the Superior Court in different counties in California, and I continue to do that until the court is closed in March. Yeah. So, and I enjoy that very much. Okay.
That's great. Thank you, Judge, for adding that. David, tell us your perspective and your observations on how you see in terms of how trial prep ends up showing up in the courtroom and what could be done differently.
Well, for me, it's really exciting when I get involved very early on. What I bring to the table is know your audience. I want to take it back to how the jury is going to see it, what the jury is going to think. And it's been really exciting when I've gotten involved in a case very early on where we might just work it up with a focus group of 6 to 12 people. We might do something online. It's only about 15 minutes just to get the theme. And that ties into what Melissa was saying. Start with your jury instructions, start with your roadmap, start with the theme. Know what's going to resonate, because I have been called in at different stages, sometimes when different counsel is brought on because they're like, holy cow, this is actually going to go to trial. And then the case has been worked up in a manner where we'll take it to a mock trial, and I'm like, uh-oh, you've hung your hat on something that the jury isn't buying. So if you're going to take a product to market, you want to know what your audience wants, needs, what the strengths are, what the weaknesses are. You want to anticipate all of that so you can bring them the best product possible. So the earlier you get involved, you can do small-scale stuff and get a really good idea to go forward. So from my perspective, I get more excited when I get even a small project early on and get to help shape the case and the narrative and themes, as opposed to having something that's already packaged and try it in a mock trial format where it's like, well, it's a little bit harder to move at that point.
If it's all right, could I ask David, how often does that happen? Do you, in sort of, is it only bet the company kind of cases, or do you see that type of strategy employed strategically with any real frequency?
I've had it happen, sometimes I'll have it happen where they're like, this hasn't even become a lawsuit, but we're 100% sure it will. And we want to, because attorney's fees were going to be involved should the plaintiff win. They're like, we just want to nip this in the bud as soon as we can. What's this worth? And then I'll do a web survey with maybe 250 people and then give them a value. They have a sense so they can settle it as early as possible. And it really depends, because I'd say maybe about 15 to 10 years ago, it was always a mock trial. That was the only format. It was once the case had been worked up. And more I've been involved earlier on, whether it's through deposition prep instead of trial prep for a witness, or preparing a focus group instead of a mock trial. And it kind of varies, but it's moving up to where I'm getting involved earlier and earlier. And with the plaintiff litigation, sometimes they'll get us involved very early on because they just want to have a firm idea of what's going to sell, whether the case is going to sell, whether or not they need to settle or advance it to trial.
Mm-hmm. Does your company, sorry if you don't mind my learning real quick, do you charge by the hour then for that type of work, or is it a flat fee assessments, or how exactly does that work typically?
For the projects, especially the smaller scale ones, I give just a flat rate. Here's what it's going to be for the project. Here's what it's going to be, including all professional fees, including everything, because I know cost is a huge factor, particularly earlier on. Mm-hmm. So every kind of project, and part of that's because sometimes I get really drawn in and I'm like, I really want to run stats here. I really want to do this. I really want to do that. Yeah. So it's just easier for me to go ahead, do a flat rate. Everyone knows what it's going to cost up front, and that's what it is.
Thanks for letting me do a little due diligence.
Yeah, no, jump in. And for the audience too, if you have questions, feel free to jump in. So just a second. Apparently you cannot hit mute and also go back at the same time. There we go. So sort of dovetailing on some of what David was talking about, David and I have been brought in together at the last minute several times when maybe discovery wasn't thought about early on. And so the next part I want to talk about with everyone on the panel is not just case inception and how to mold the case, but how maybe we could do discovery different, thinking about down the road that the case may go to trial. I have a couple notes, but from personal experience, a lot of times I got hired kind of near the tail end of the case when either the motion for summary judgment was lost or, and not always hired, but sometimes within my firm, it would get funneled up to me at that point. Or mediation fell apart. And so then they come to me and say, Kristen, help us, save us. Now it's got to go to trial. And it's a lot more difficult when discovery's kind of been set in stone and videotape depositions have happened of our client, or we've given requests for admissions answers. These are all not hypothetical situations that I mentioned. So some things that I noted that maybe we can talk about are having a plan. I started mentoring younger associates when I realized that there wasn't always one, and they would just go into deposition. If, for instance, it was a mortgage case, they'd have their outline for their MSJ and they just ask about some legal issues, basically. And by the time I got the deposition of the plaintiff, I'm like, we know nothing about this person or what they think they're going to get or their damages, or are they emotionally, we know nothing. All we know is about this very narrow legal issue. So know your purpose in the deposition. Are you trying to test the credibility of the witness? Are you trying to win an MSJ? Are you trying to figure out how they'll fare at trial? Are you doing all of those things? But have a purpose for your deposition and then develop a discovery plan. I feel like people play defense, especially in civil, way more than they should. Everything's reactive instead of having a plan. And I get it that there's cost considerations, but there still needs to be a plan with those in mind. I find from my DA days, and for the DAs on this, the criminal lawyers tend to understand the evidence code better. And by the time you get to deposition and trial, that becomes very important. I find that the civil lawyers tend to know the CCP better or the procedures better. Knowing both is really important, I feel like, for trial preparation. And then obviously knowing the differences in deadlines and what's expected in both non-expert and expert discovery.
Mm-hmm.
So, Melissa, can we
I
get
think
your
in
comments
criminal
on discovery and how we can handle that different?
Yeah, I
think
but it sounds like John has a comment. Yeah, Your Honor.
Oh, Judge,
I
go
think
ahead.
in criminal cases, the judge has more discretion in changing the discovery deadline, in changing the deadline in general, because there is a sense of justice requirement, and that we are allowed to do that sometime and many times. If you consider balancing the equity in the case and what justice demands, we can have some leeway. But in civil case, most of the time, the judge cannot deviate from the deadline set up by the court, unless very specific and compelling evidence dictate otherwise. I rarely change the deadline because the duty of counsel in civil case is so incredibly heavy to fulfill the obligation for discovery on time. Otherwise, the judge will be taking side of the party who failed to do that and help that party. So most judges would not do that.
Yeah, I was going to say I'd like to be in his court, because I would say I find a lot of permissibility in terms of, in fact, if anything, I get the sense that you can rely on a plan and work to a plan, and I would say the default more frequent outcome is that there's a permissive variance to permit, deadline extensions, and when we're typically the defendant, I'd rather keep some boundaries on plaintiffs' lawyers. But it's interesting, right? Because we work in so many different jurisdictions. There's so many different approaches. But one thing to point out, and this is sort of counter to what I feel like I would have said 6 months ago. So I'll bring up, just sort of a time relevant thought I've been having. But this is not meant to be negative, but we've seen and anticipate significant turnover outside of the norm within the organization over the, and I worry about preservation of witness testimony, and, particularly when we deal with cases all over the world. And I would say, I don't know if this is an interesting tangent or not, but it seems I'm already thinking about wanting to video our own witnesses in some ways and think of them as again, kind of the permissibility of that I've seen with a lot of judges. Think about the possibility we'll need that testimony in what would normally otherwise be a discovery deposition that the plaintiff is using to trap someone as the actual testimony if we can't compel them to come, to the jurisdiction or something like that down the road. And so I'm thinking outside the box about possibilities like that with some witnesses. And I would never have said that 6 months ago, which just shows what a dynamic environment we're sitting in right now.
Wow, that's so interesting. And delivering that message to the witness and why we need to do that is interesting.
It's not personal. It's not even personal necessarily, right? It's like, you're a critical witness. I can predict that we may need your testimony no matter what. And by the way, they would never understand that. You don't have to tell them. but fair enough. But it's not something we would normally want, normally push to do on the defense side, and certainly, and maybe even, the questions we ask and redirect and things like that. I'm thinking through situations where we might want that, particularly too when you deal with a lot of arbitrations where the likelihood of everyone just dropping it and that testimony coming in is very high.
You'd probably have to do it with opposing counsel and allow them to cross-examine, right? So almost conduct a deposition of your witness.
Mm-hmm. Well, again, I have to think about it too, because it's not necessarily that you would declare it's a trial deposition.
Right.
Dean.
Kristen,
Good point. Yes.
We're starting to get some questions around the virtual part of all of this. Things about like, this one question is about remote depots. Would you be providing the exhibits in advance?
So let's go there. What? My presentation that way. All right. Sorry. Again, can't do mute and move the slides at the same time, apparently. So one of the areas we do want to focus on is how is COVID-19 going to impact this? And good question. One of the ways is right now, at least, we're having to do virtual depositions. David, what are your thoughts from a jury consultant's perspective? Is that a good thing or a bad thing? Or neither?
It could cut either way. And it's interesting from doing shadow jury, where I have a jury that is of my making that's comparable to the actual jury. And we bring them in and out of the courtroom and we interview them individually each night to have a good feeling for what stood out today, what witnesses stood out. One thing that I've learned over time, whenever deposition videos are played, should someone resort to playing that instead of calling the witness live, their eyes kind of glaze over and they don't get as much out of it. I think it would be interesting as far as it's such an informal type process when you're deposing somebody. The witness's anxiety might be a little bit down. The witness is in a more familiar setting. The witness might be able to do a better job in a setting such as that. Just thinking as far as what would be like for the witness and, you know, the perceived credibility of that witness.
Yeah, one of the issues I see, and Melissa, I don't know if you've had this experience yet, but especially if it's a more minor witness, I don't think it matters. I've used video testimony where we did remote depositions at trial, and I think it was fine. But typically I was in the room and opposing counsel wasn't, or at least the court reporter was in the room. Right now, you've got a situation where nobody's in the same room. So client conferences, you have to say, just a minute, I'm going to go pick up my cell phone and call. And, you know, it's just a whole different dynamic. Exhibits, I never found it to be a real issue. If the case is going to go, I give it to them ahead of time, maybe an hour ahead of time. If there's really a gotcha moment, there's going to be a gotcha moment. So I don't personally subscribe to the fact that they get a little time to look at it.
I guess I would say this is back to, you know, we've done video or even telephonic depositions since as long as I've been practicing law. So it's not that there's something so novel about that, but so on the one hand, I would agree that it is that feedback my fault or somebody else hearing some feedback on mine? You know, is it always, in most cases settle, right? So I would agree that it's inferior. I would never prefer it in a case that would call it one with actual, you know, material loss exposure to do it that way. But most cases, if you're playing the odds, I actually think there's room for increasing the use of video and telephonic depositions from a cost benefit standpoint. But, you know, it has to be done you're taking some risk when you do that, in my view. I do agree with David, you know, even when I mentioned that, you know, assuming the possibility, I'm talking about hedging for not being able to compel someone, you know, into a jurisdiction or not wanting to go through the hurdles or something like that. It's not about, and we deal with cases all over the world, so there's issues like that. But it's not, I would never argue it's better to have a video deposition. But am I gonna, if 99% of cases settle, did it get us 80% of the week there most of the time on most issues? Probably. So I think we'll probably, you know, maybe use this as an opportunity to push for more use of that in some cases to save costs where we think it's the plaintiff is just trying to run up costs to get us to settle. I could see myself using that argument that, oh, everything worked okay during COVID. Almost impossible for me to imagine. I don't know where the course will go with this. You have a view. It's almost impossible for me to imagine voluntarily agreeing to a virtual jury. But I might agree to a virtual arbitration in some some cases.
Yeah,
On the
I
state.
agree. It scares me to think that we would even consider having a virtual jury. Judge, what are your thoughts?
The jury trial and jury service is going to be a very difficult problem for the court to resolve. As you can see, the setting of the trial of the jury box doesn't give you any space at all, other than 12 jurors and 3 alternate jurors in the box. That's it. Unless you can use the room, the entire jury courtroom for jury to sit apart of each other, and then it's very hard. But in terms of the COVID-19, I think that this situation will bring all parties together: the plaintiff's bar and the defense bar and the court. Three components of the court system, of the trial system, will have to work together, have to come to a common understanding that we are facing an extremely difficult situation and need to work together to resolve it. So I think virtual deposition or trial by the WebEx, for example, internet connection like we're doing right now, I think will happen. It will come to that point sometime. If the COVID-19 continue to go on for another 6 months or more, or another year, we cannot keep the court stopped working, because the party need resolution for their cases. And this is a time, I think, to help the party to resolve the case more so than any other time. Do you agree with me, Kristen and Melissa?
I agree it's untenable to have, particularly in criminal cases, delayed justice, prolonged this. I don't know that I agree that the parties come together. And it's hard for me to imagine, and maybe I'm just more cynical. I hope I grow to have your view, that the plaintiff's bar and the defense bar is going to, I see more opportunity for strategic use and strategic manipulation of the circumstances, and depending on whichever side perceives as better or worse for their situation. Because there's some good arguments to be made on both sides about why, your system of your quality of justice is impaired, or the need to have urgent justice is necessary. So I see a lot of argument around those types of things coming up, and my guess is it's going to be self-serving.
Yeah, I think, Judge, you're speaking like a true judge, an objective. Everybody needs to play nice together. I mean, I have noticed a very big difference going from the criminal world, how nicely everybody played together, compared to the civil world. And there's much more, it's not fair, and there's more gamesmanship, and on both sides. But frankly, I'm probably a pessimist because I see it more on the other side that I'm not on. And, in the end, we've got to position the case the best for the client. So it scares me that we may be talking about, for social distancing purposes, fewer jurors or longer voir dire, because that makes the case more expensive for the defense, not necessarily the plaintiff. And it, to me, tips the scale unnecessarily and unfairly. So, I want to get David's thoughts, and I know he's done some jury research on this.
We actually have a question right around that, and that is to David, and that is who will actually show up as jurors?
Mm-hmm.
In this
There
situation?
you go, David. Perfectly said, Maggie.
That is an excellent question. And I'm going to segue into that from what you said, Kristen, because you were talking about, from a cost perspective, bringing in fewer jurors and elongating the voir dire process it's costly by an hourly basis, but it could be less costly overall because it gives us better input. When you have a smaller group of people, they're going to be more apt to disclose information. You're going to have more time to talk to them. They're going to be more comfortable because the courtroom doesn't have as many people. They're going to be spaced out. All of those things facilitate disclosure. So that's a good thing. Secondly, it is definitely going to impact jury composition. Because if you think about it, people who fall into a higher risk are going to likely be less inclined to want to show up in an environment where they're going to be in a group, which we've all heard, don't be in a group of over 10, don't be in a group of over 50. And they're like, wow, I'm going to go into a building. I'm going to be in this, area with this stagnant air. I'm going to be sitting around a bunch of strangers from all walks of life who've been exposed to who knows what. So you could find fewer individuals who are in the higher age group. You could find fewer retirees. You could find people who are more apt to dismiss the threat of this. You could find people who think, okay, the economy and all these things are much more important than protecting people who are vulnerable, who can choose to stay home. You're definitely going to see a selection bias as far as who responds to the summons, who throws away the summons, or who defers their jury service. And then you're also going to find a lot more hardships. You talk about extending voir dire. When it comes to hardships, people who genuinely are concerned are going to opt to get off. And then people who see that as a viable route to getting off of serving as a jury or as a juror, even if they're not concerned, will take that route as well. It really is going to narrow the jury pool, and it's going to elongate the process. There are good things that come from that, and there are bad things as well.
It's funny, as David was talking, I was thinking about this. I mean, I'd take $50 to go sit with 10 people I haven't seen for 2 months, any day of the week. I would opt in, right? And it's got nothing to do. I think you could find a group of people. I don't think you would have difficulty finding an adequate number of people if society stays shut down and the courts were to resume, willing to opt in. But that's a total, right? And historically, there's been a high degree of showing to get out of jury duty. I think it'd be interesting to see the psychology of the type of person who, and I don't even know if it's necessarily dismissive of the risk, it's owning, accepting of the risk, whatever, or willing to, take a personal risk assumption or something like that. And if in that attitude alone, psychologically, I think would be more likely to yield different outcomes from jurors than you would get if you had a general pool. And I don't know if that will happen. I have a feeling the courts will probably find a way where we just don't bring people back. And that'd be my guess, or maybe there ends up being, what are those things called that they have at the grocery store now with the plastic? I don't know what, there could be.
We all have our own little cubby hole.
But I don't know, and I'm not alone. I mean, I know people. I think there are people who would be happy to just be like, that's where I'm going now. I'm done with the monotony. I'm on a jury, and that is a different psychology than the people that are more leery than not. And it might be people that in a normal world would never consider rushing in to volunteer.
And I will tell you, there's going to be a selection bias. And from the research that I've done, as far as doing online research with a case and then statistically looking at which questions predict plaintiff and defense outcomes, people who are the most scared of COVID-19 are the ones who are the most plaintiff-oriented. And those individuals are likely to defer, I would say, jury service because of their fears.
I was sort of having that evolving thought as we were talking, David. So I'm now officially in favor of resuming jury trials on an option basis as soon as possible.
Panelists, we have another question that pertains to this, and it can go to all of you. How do you all, what do you recommend? How do the panelists recommend with dealing with potential anti-Asian juror bias relating to COVID-19?
Judge, that sounds like it's something up your alley with all of your work with the Asian American students and with the organizations. Do you have any suggestions for that?
I think that issue will arise, obviously that's the reflection of what is going on in our society, but I think you can overcome that. I think if you call to the jurors, talk to them, ask them to exercise to use their conscience and fair judgment in judging the case. We cannot eliminate all bias and prejudice from a few people, but I think you can ask the people, common people, to be fair And that's my experience with jurors, jury services, and with jurors when we do voir dire. But it will happen. There will be people say, well, I don't like Asian people. That guy's Asian. I will never give him, I'll find against him. That doesn't matter what. That's a contaminated jury pool, but it will happen. It will happen. Yeah. I had a trial where a person, I asked, can all of you be fair with this person because he was Hispanic interpreter, Spanish interpreter for this trial. The gentleman rose and say, I don't like Mexicans. Why don't they do it exactly as I did? I spent $100,000 to come here from England to pay my lawyer to become a citizen. Why did they sneak into our country and demand everything that we have? I cannot be fair in this case. I will rule against him. Doesn't matter what. Okay, so that will happen.
Did he get out of it?
What's that?
Did he get out of it?
Oh, of course, of course, of course.
Sort of dovetails into something we skipped, but one of the generally optional trial documents is a jury questionnaire. A lot of times, and so I'm just wondering, I don't always love doing this. David, you can give your pitch for why it's a good idea. And the reason I don't always love doing it is because most judges think that counts against me in terms of my oral voir dire time. And that is precious to me and I'm not willing to give it up. And so if they think it's an either or, I'm going to let the questionnaire go. But if it's a both, if I can have both, and maybe this extended voir dire time allows us to have both, then I'm thinking this might be a good area for the juror questionnaire so that I don't have to address those issues as the lawyer, but they can be dealt with in the questionnaire. What do you think?
I think that the scariest, one thing that I'm always on the lookout for are the people with extreme beliefs, the people who deviate from the norm. And those individuals are not going to identify themselves. They're not going to identify the biases. So you have to go about it indirectly. And the best way to go about it indirectly is through a juror questionnaire. People are twice as likely to disclose something on a questionnaire as during oral voir dire. And they're 2 times more likely, or 4 times more likely to disclose something on a questionnaire compared to attorney or judicial voir dire. So the thing that's really important, and what I've found with cases where there could be gender bias or there could be racial bias, I use a little like thermometer that I draw, and then I say, how hot or cool are you on certain issues? And it doesn't ask, hey, do you have bias? Hey, are you racist? Hey, are you this? Hey, are you that? It kind of gets at the issues in a certain way where people are more comfortable to disclose information. And really the best way to do it, and almost the only way to do it, is on a questionnaire. So if that's a significant issue, I would advance, even if it's a single-page questionnaire, so you don't lose your voir dire time, really get at those most sensitive issues, because you do need to identify those individuals. The other way that you can identify those individuals is through social media searches, and you can really find out quite a bit of information based on that, if only their political bent, but certain extreme beliefs, because the people who are the most extreme, who you're looking out for, are the ones who are apt to use social media to promote that ideology. So those individuals can be spotted, found, and removed.
Mm-hmm. Yeah, I mean, I'm actually, it's interesting because you know, every jurisdiction's so different, but getting the jury questionnaires back the day before the trial started was sort of a rite of passage in Ohio, where and to David's point, it was, we got the questionnaires, we've got a team of 10 people back ready to start cyber stalking everyone. And I think that was by far the most informative way to come up with presumptions about juror bias and things of that nature. So I've actually been surprised that it's not only that it's not common everywhere as I came out of that jurisdiction, but also that it's not, you don't even necessarily get the names of the people in advance in all jurisdictions. So, just a very different approach.
Do you allow jury questionnaires? And if so, do you give the attorneys time to go decipher the results?
Of course I do. But the problem with jury questionnaire is that they are used more in high-value cases rather than the run-of-the-mill cases. So I don't know, but in this situation, it might change because of the COVID-19. It might change, I think. Yeah.
Yeah. Well, maybe that allows us to change a little bit to, I did want to mention just because it was a topic in one of the other webinars we did, not only from the getting a case ready for trial depositions and the impacts of COVID-19, but I don't know if anybody's seen some of these articles that there are now subpoenas for Zoom recordings and WebEx recordings. And I'm not sure, or I actually I'm pretty sure, those would have been fair game before, but they just weren't commonplace. And so just be cognizant of the fact that all you have to do is hit the record button, and those are probably discoverable. And so board meetings and things like that, you could all end up on a big screen as Exhibit B.
I think you're right. I was actually talking about this morning at a roundtable, but it's very, you're right. I'm certain it was probably discoverable before, but people just was one of those things off the radar. And a lot of companies, and I think we fall in this category, I think trying to do the right thing in this environment, which is no good deed going unpunished, will undoubtedly be reviewed with hindsight and in a way that looks for errors and problems. But we're trying to be very transparent. We have these leadership perspective meetings. We are having lots and lots of, if anything, I think we're over communicating. And I think that's right. I think it's the right answer from a just acting in good faith, being a reasonable corporate citizen standpoint. But the flip side of that is we're creating records upon records of senior executives talking off the cuff, answering employees' questions, showing the sausage being made. And I do worry about how that's going to be used and abused, frankly, by plaintiffs bar in the on the other side of all this.
I do too. It'll be interesting. Well, let's there we go. David, if you want to give us a couple minute just primer on, because I've heard a couple times, I think the judge mentioned Bet the Company case. I've taken very few, only one that I can think of in my whole history, other than as a prosecutor, arguably the murder cases are Bet the Company cases. But I've worked with you on a number of non-Bet the Company cases in a way that we were able to make it affordable. So give us sort of your ideas, and then I'm curious from an in-house perspective and a judicial perspective what their thoughts are on jury research and using a jury consultant like yourself.
Okay. Well, we can do a variety of stuff, be it something online, which is what we've been confined to now.
Sorry to interrupt, but just for time sensitive, if you can also apply it, maybe for some opportunities right now that exist because of COVID-19.
Yeah, as far as doing online things like that?
Yeah, or how it might apply.
Sure. So as far as a study that I'm doing right now, which we're very interested in getting early on what themes are resonating, what's not resonating, how can we convey that visually, where we just basically do something online where people watch different video conditions where they're randomly assigned to, one of three defenses, different kinds of graphics, what works, what doesn't work, getting open-ended feedback. And the whole time that we're doing that, we're also collecting questionnaire data up front. Because not only are we looking at how can we widen who's going to accept our case, how can we widen who's going to accept the arguments that we're making, and how can we refine the arguments, but also who's most receptive and who's least receptive. So whenever I'm doing this kind of research, I'm constantly building a database statistically showing who's a good juror, who's a bad juror, and going into jury selection with that theory. Here are the 5 worst qualities in a juror for our case. You need to know that up front, because when you get up there and you're doing voir dire, it's amazing how voir dire drags on and on and on. And then bam, you all of a sudden have to make your mind up very, very quickly. So you want to go in with a plan. So the whole time, plan up front as far as the narrative, the roadmap you're going to take, the themes you're going to take, and constantly tweak who is going to be a receptive juror, who's not going to be a receptive juror. Every now and then we have a case that it just goes 50-50 whenever we test it. And that's scary. You know, this could go one way or it could go the other. And honestly, I don't know which way it's going to go. And then when those go to trial, that's when I try to get a shadow jury. And you bring in a matched jury. And sometimes, if it's a big case, you can have the shadow jury in there every day of trial. But I say, you know what, at least have them in for the first couple of days. Have them in for openings, for the first key witnesses, interview them each night, and then you have a good feel of which way this case is going to go, what's resonating, what's not resonating. And it gives you an idea when you compare it to the research you've done, you know, maybe this is going in our favor or maybe it's not.
David, how often does your shadow jury end up agreeing versus disagreeing with the actual jury?
The shadow jury it's pretty remarkable because what we try to do is I will get a panel of maybe about 20 people who can serve as shadow jurors. Once we impanel the actual jury, we bring in people with similar backgrounds, similar work experience to the degree that we can. And I would say, as far as when they're talking about different kinds of damages, when it comes to numbers, you never know where a jury is going to fall. That's just so kind of random sometimes. But it's very closely parallel. The issues, they're identifying the same issues, the same concerns, and often the same verdict preference.
Interesting.
So you've shared a little bit, but what are your thoughts from an outside counsel perspective and having to manage costs about when you would use a jury consultant?
Yeah, I mean, and I think I've been transparent to think about this. I mean, it's because I operate with the assumption that most cases are going to settle. It's a hard sell early on, honestly, but I'm open-minded about it, particularly if there are lower fixed cost structures or, you know, ad hoc project-based types of things, particularly in a material case. But I agree. I mean, I have no doubt of the value of jury consultants, but it is not something we've used frequently at Flex, admittedly, nor is it something I used frequently in my prior life. But I do think it's valuable, and I do think the question always comes down to, and if I was giving advice to a guy running a jury, you know, how can you convince me of the value? And it's going to have, you know, particularly when you're looking at a situation where forgivingly 9 out of 10 cases settle, you know, and usually without much intervention, right? If you're really, I get the idea if you're really trying to investigate approaches to settlement and things like that, but if that's the sell, that's the hard sell. And so I think it's got to be priced appropriately if there is a market. And I'll admit I didn't know, you know, if there is a market for cheaper early case assessment type of jury research consulting, I'd be more open to that than, I'm not suggesting, it's actually reasonably affordable at the end of the day, but it's all ROI.
Yeah.
Kristen, we have just a couple minutes left. We have one more question here, and you all have touched on the fact that, you know, typically lawsuits don't necessarily go to trial, that they get settled. Do you think in this virtual environment, any of you, that there will be more settlements or less? Or does it have any impact at all?
Strongly that there will be more settlement in this environment. There will be many, many more than before.
I agree, and I've already seen evidence of that in some of the matters we're dealing with.
Yeah, unfortunately, I think that's right. I think people are going to lose patience and worry about what's going to happen and the unknown of how trials will play out. In fact, I had a few slides ago, some of the Orange County judges, the only thing they've posted about how trials are going to be different is that they're going to have voluntary settlement conferences and some other kind of settlement conferences. And I'm like, that doesn't answer the question at all. We weren't asking about settlement conferences, but there seems to be a focus on getting things settled. So what are your thoughts, David?
I think there will be more settlements, and I think the cases that make it to trial will be due where the sides aren't coming together and they'll be more extreme, maybe higher value. I think the ones that do make it to trial will be very interesting.
Interesting thinking.
Maggie, I was going to ask for parting thoughts from the panelists, but are there any other questions you want to make sure we handle first?
No, those are the questions that we had.
All right. Judge, do you have any parting thoughts that you'd like to share with the audience in terms of COVID-19 impacts on trial or trial preparation?
I'm going to give some general recommendation for jury trial. I saw a slide that we say the jury is watching. The jury is always watching you, counsel, always. So my thing is that you have to have a sense of humility before the jury. You have to be sincere. Your argument has to be based on your confidence and belief in the case that you have. It has to show to the jury that you are well prepared. You're not surprised at anything that's thrown at you at your side by the opposing counsel. But the sense of humility is always important. I had a case that resulted in the largest verdict in the state of California in 2017. It's a quadriplegic case. Defendant in that case is a young white American officer of the National Guard, Air Force. Plaintiff is a Hispanic guy. It's the name of Francisco Briones. The verdict is $125 million. Counsel for the defendant presented an expert witness for future economic loss. And that expert witness says to the jury that, ladies and gentlemen, don't give him much money because this is what he's going to do. Giving him everything he had before the accident, he would never get a college degree. He will never get beyond high school because my statistic, based on my research, is that only 3 to 4% of Hispanic people can go beyond high school degree. They will never.
Are you there?
Are you there?
Yeah.
Can you hear me?
Yes.
Only 4% to 3% Hispanic people can get full-time job. Never get beyond minimum wage. And on the jury panel, 4 Hispanic people. They cry when they look at the plaintiff. They cry. And how could you present such an expert? How could you present such a testimony?
Good example. Melissa, any parting words?
I just say, I hope to meet you guys live on the other side of this. I think that it'll be fascinating course to have for a decade, if not the rest of our lives.
We'll do it in person.
Yeah.
David, parting words?
I think building upon what the judge said, when I was studying the impact of attorney characteristics during voir dire on case outcomes, jurors very much notice the attorneys, have nicknames for the attorneys. They think that if the attorney does not show like he or she is prepared, that they personally are offended by it because they personally feel that the attorney is wasting their time. And in the case that the judge illustrated, the attorney offended the jury's sensibilities. And that's something that people always need to be aware of. And then the other takeaway would be, if a case does look like it's moving towards settlement and there's a big difference between what both sides are thinking is reasonable, there's still always online quick research where you can get feedback from hundreds of people at an economic cost, and you don't have to go in blind, and you kind of have a better feeling of what the case is really worth. So you can always get feedback.
Yeah. Well, I agree. My law school professor taught me, she calls it diligus. Do I look like I give a, and so when you're in the court, you don't let the jury see you sweat. Nothing phases you, even if your whole case just got taken away. I feel like what I've learned as I've gone through is you got to apply that even before you get to the courtroom so that opposing counsel doesn't know where to push buttons, both with you and the witness. And there's a lot more gamesmanship to it in terms of that. So interesting discussion. I agree. Cheers to everyone. Hopefully we can do this live next time. Thank you to our panelists for joining. Thank you to the audience. Stay safe, everyone.
Thank you. Be safe. Thank you.